Have you ever played chess? You know how great chess players don't just think about their next move, they think several moves ahead? Well, that's exactly how we're going to think about our expert witnesses, and in particular, the defense expert witnesses.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it? That's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling. In this episode, Tom reveals how he turns dry expert testimony into compelling information that builds a strong foundation for your brain injury case. Let's join Tom as he explains the critical importance of correctly sequencing your experts.
Welcome back to Winning the TBI Case. I'm Tom Crosley, and today we're talking about one of the most powerful weapons in your arsenal when trying a brain injury case: expert witnesses. Now, I get it. Expert testimony can be dry as toast. Nothing can put a jury to sleep faster than some PhD droning on and on about diffusion tensor imaging like it's a grad school seminar, right? But here's the thing. If you sequence and present your experts the right way, you can make them your star witnesses. Not just proving your case, but setting up the knockout blows that take down the defense before they even get started. We're going to try to prove the injury is real before the defense ever gets a chance to prove that it's not real. And we're going to drill that point home so sharp and so early that half the battle is already won after 2 or 3 witnesses into the case. So let's break it down. How do you turn expert witnesses into your TBI case's secret weapon? You start, number 1, with the most irrefutable objective evidence. Picture this. You're on a jury. The plaintiff lawyer steps up and tells you about this case, says it's about a brain injury. The first witness takes a stand, and it's the plaintiff. Bad move. Why? Because now the jury is making snap judgments before they've seen any medical evidence. They're looking at the plaintiff thinking, hey, they seem fine. What's the problem? Why am I even here? So instead, we start with the science. The best way to make jurors believe your client is injured: show them hard evidence, the kind they can see with their own eyes before anyone ever tells them what to think. That's where your neuroradiologist comes in. This witness is your show and tell expert. Every trial ought to be a show and tell. We're going to engage all those senses, and people tend to remember and believe things they see much more impactfully than things they only hear. So make your trial a show and tell. Your radiologist is going to come in and they're going to show high resolution brain scans on a giant screen, and they're going to walk the jury through the damage, through the abnormalities, through the brain tissue that is now no longer normal. They're going to trace it out. Maybe they're going to have colorized scans, but you're going to make it a show and tell. See this dark area? That's where axonal shearing occurred when the brain twisted rapidly inside the skull. They're going to show it and tell it. See these bright spots? These are micro hemorrhages from the impact. That's where there was these microscopic areas of bleeding within the brain, and the blood eventually dried up, but it left behind these iron deposits. And on this scan, those iron deposits show up as white. And we know that means there was trauma to this area of the brain. See this difference between the left hemisphere and the right hemisphere of the brain? See this volume loss? See this area that's smaller than this other corresponding area? That's atrophy. It's like when you damage a muscle and you can't use it anymore and it shrinks. The same thing is happening in this person's brain. And because it's in this area of the brain, that's why the plaintiff now has memory and mood issues. We're going to show it and tell it. And it's going to be impactful, especially if we can lead off our case that way. So at this point, jurors aren't being asked to believe anything yet. They're not being asked to take your word for it as the lawyer. They're just seeing objective proof of injury. It's like handing them a puzzle where the edges are already built, and they're naturally going to fill in the rest on their own. And here's the best part. By locking down the physical proof of injury first, you've now made it much harder for the defense to argue that your client is faking. Because let me tell you, if a defense lawyer tries to argue that a brain injury isn't real, after you've shown the jury the MRI and DTI scans proving otherwise, well, that's when you just sit back and watch the defense lawyer dig their own grave. That's when the trial becomes really fun. So next, we're going to connect the science to the real world. After the jury has seen the brain damage, now they need to understand why it matters. So enter the neuropsychologist. This witness is your bridge between hard science and human impact. They're going to take the MRI evidence and translate it into daily struggles the jury can relate to. Because this damage is in the frontal lobe, the plaintiff struggles with impulse control and decision-making. Because of axonal shearing in the hippocampus, they can't retain new information very well, which makes holding a job incredibly difficult. That would explain the results we got on this testing. That would explain why their boss keeps having to call them into the office to fix something 3 different times when they never did before. That would explain fill in the blank. You see where I'm heading with this? Due to damage in the amygdala, they experience sudden, uncontrollable emotional outbursts, and that hurts their relationships. They're emotionally volatile now when they didn't used to be. We're connecting the pieces. I like to refer to trying a brain injury case as building a wall of evidence, one brick at a time. And I'm starting that base layer with my strongest foundational bricks. And then the question is, how high can I make the wall through the life of the case? So now the jury, after we've developed this kind of testimony, they're not just seeing the injury, they're feeling it if we're doing it right. They're starting to picture what it would be like if they suddenly couldn't remember their kids' names or birthdays, or if they couldn't focus long enough to drive, or if they forgot the directions to grandma's house that they had driven to many times before. Or in one of my cases, the guy was a custodian at a high school, the handyman at the high school. And he had taken a lock apart and had to put it back together. And he was just, one of his coworkers testified, he was just staring at all the pieces of the lock that he had disassembled, and he couldn't figure out how to get it back together. And this had been his job for 30 years. This wasn't like the first time he was putting a lock together. This was somebody who knew how to work this puzzle before the injury and now wasn't able to connect all the pieces. It was powerful. All right, so here's a tip. If your neuropsychologist is comfortable doing so, have them demonstrate some of the tests they ran on the plaintiff. I mean, some of these tests go on for 4 or 5 hours in length, but it could be something as simple as this. Oh, in this test, the plaintiff has to repeat a list of words like apple or chair, and they have to repeat them back to me 5 minutes after hearing them. And the average person without a brain injury recalls an average of 4 of the 5 words. And this person only recalled 1 after 5 minutes. I mean, there's going to be so many different tests that your neuropsych probably ran on the plaintiff. And you're only going to discuss the ones where there were deficits consistent with injury. And you're going to have them relate what is that test designed to ferret out, and how does it show deficits on your plaintiff? And we're usually looking at deficits that are on a bell curve significantly abnormal. So where your plaintiff is in the bottom 10%, where all their other scores are in the top 25%, that kind of thing. And it's usually a few different areas of brain function. It's not the total brain that's been affected. And so whatever that is, that your neuropsych is going to help guide you through that, but you're going to have them explain what the test is designed to do, how this person didn't do well on it, why that's important. You're going to discuss perhaps concepts like scatter that we can get to when we get into our deep dive into neuropsych. And scatter is the concept that you have, say, most of the scores in one end of the spectrum, but scores that are significantly different that show scatter help neuropsychologists identify areas of brain region that are abnormal in function. And hopefully that will correlate with what your neuroradiologist has found also. So we're building that wall, one brick at a time. And sometimes we're cementing 2 of these bricks together to tell a really good story. So these are powerful moments because now the jury isn't just taking the expert's word for it. They're seeing the deficits in action. And we're going to blend that with some of these clips that we've previously taken from the videotaped deposition of our plaintiff, where we can introduce the plaintiff and some of these deficits so that the jury gets a feel for the plaintiff themselves long before the plaintiff comes into the courtroom. We're also going to use our experts to set traps for the defense. And this is where it gets fun.
If you're finding value in today's episode, here's how you can take your TBI practice to the next level. Subscribe to our newsletter at crosleylaw.com/podcast for exclusive case studies, resources, and trial strategies you won't hear anywhere else. That's crosleylaw.com/podcast, or click the link in the show notes below. Don't just listen to the strategies, implement them.
So, have you ever played chess? You know how great chess players don't just think about their next move, they think several moves ahead? Well, that's exactly how we're going to think about our expert witnesses, and in particular, the defense expert witnesses. Here's an example. Let's say you know the defense is going to call their neuropsychologist, their hired gun that they use in 95% of their cases, to argue that your client isn't really injured. Maybe they'll say, well, this person performed fine on these cognitive tests, X, Y, and Z. And they're going to try to say, because they performed fine on certain tests, they must be fine. So how do you stop that argument before it even starts? Simple. During your neuropsychologist testimony, you set the trap. So you might ask your own neuropsychologist when they're on the stand, you might say, Doctor, are standard neuropsych tests enough to diagnose every brain injury? And the doctor might smile and say, no, not at all. And you would say, well, why not? And he or she might say, because they're performed in a quiet, controlled environment. But a brain injury really affects people in the real world, where there are distractions, stress, multiple tasks happening at once. It is rare in real life that we get to put ourselves in a quiet, controlled, distraction-free environment. That's just not how the world works. And so now you've got the defense expert, when they try to argue that the plaintiff did fine on certain tests, you've already got that preloaded response, which is, yeah, but that was a quiet, controlled environment. And that's different than the real world where this injury affects the person. Because the tests don't often show how hard life can be for the person who is so easily distracted. Imagine, let's say, take yourself back to high school or college, and you're studying for a final exam. Ideally, you're studying in a completely distraction-free environment. And you're internalizing that information, you're absorbing it, you're doing really good. Now take the same person, the same analogy, but it's a brain injury that causes an inability to focus for periods of time. And now let's say you're studying for that same test, but every couple of minutes, somebody comes in and says, hey, what you doing? Or blasts some music or spills coffee across your workspace. But you still studied for an hour for the same test. Which of those do you think you're going to do better in? And so we're going to come up with powerful analogies like that to explain how in the real world, a brain injury, especially a frontal lobe injury, can affect performance. And we see this, frankly, in frontal lobe injuries, executive functions, where the higher thinking cognitive levels occur. So we're going to try to win the war before the battle even begins by setting up the defense experts for this failure through our own experts. There's a second way that we're going to set them up. To the extent that your state allows you to use medical literature in cross-examination as reliable authority, we're going to have our own experts identify the articles we want to use to impeach the defense. We're going to have our own experts declare those as reliable authority. So then at the very least, if we can't get a defense expert to agree with us, we can at least make them read what the science and research shows that supports our position. And that becomes kind of a fail-safe cross-examination technique. I'm going to cover that in some detail when we get to cross-examining the defense neuropsych. The next thing I want to mention, we've got to keep the jury awake. So we've got to make the experts relatable. No matter how great your expert witness might be, if they sound like human Ambien, your jury's checking out. So whenever possible, pick experts with personality. So 15, 20 years ago, I would go to brain injury conferences all the time. I would hear all these different doctors speak, and most of them would just get up and drone and some of them would be very entertaining. And I would walk up to the entertaining ones after the fact, and I would strike up a conversation, and I would say things like, you ever thought about testifying in a legal case? Would you be willing to do that? And so I'm trying to pick people who are good communicators. And so you're going to want to do the same. I've had it happen where I had one of my witnesses in a brain injury case on the stand for 2 or 3 hours, and it was just on and on and on. And I thought, golly, I wish I could have done this better. And so you're not always going to succeed, but to the extent you can, you want somebody who can be impactful without taking forever. We want to be short, simple, and engaging. It's your job as the lawyer to fix it. If you see the problem that a witness is dry and boring, it's not their fault. It's your job to fix it. How are you going to make them engaging? Can you use visuals? Can you cut out a lot of the unnecessary stuff? Can you start with the conclusion? I mean, you got to figure that stuff out. They've got to sound like they're talking to real people, not writing a research paper. You've got to be talking to a group of high school students, essentially. If you want all 12 of your jurors, or how many ever there are in your state, if you want everybody to be nodding and following along, it helps to have visuals. So here's a few ways that I've done it where I have a doctor who's getting a little bit too technical. I'll say, hey, doctor, if you had to explain this to a high school class, how would you do it? And immediately you've redirected that expert to kind of speak on the level that you want him to speak on. Doctor, can you give us a real world example of what you mean by that? Those kind of things. So if this were your relative, your mother, your brother, what would you tell him about what his future holds given this injury? And by the way, I don't have the plaintiff in the courtroom. I certainly don't have them in there listening to people talk doom and gloom about their future. I don't think that's a good technique. And I'm usually getting them excused by having one of their doctors say, hey, it's probably not best for their mental or emotional health to have them witnessing this. And that's a technique that we need to be able to do so that when the jury does later meet our plaintiff, it seamlessly fits together. By making your expert relatable, because these are expert-intensive cases, we can't win them without experts. So by making your expert relatable, you make your case relatable. And relatable cases win with juries. So let's recap. Start with objective, irrefutable evidence. Make the jury see the injury before they meet the plaintiff. Use expert witnesses as a bridge and translate science into real-world examples. Number 3, set traps for the defense. Don't just play defense, play offense. Number 4, keep the jury engaged. Boring cases lose. Interesting cases win. So in the next episode, we're going to dive into the power of before and after witnesses, how to find the best ones, how to coach them, how to prepare them, how to use their stories to hammer home the reality of your client's injury. We're going to come up with some techniques that will help them identify and bring forward interesting stories. Because at the end of the day, when the jury is deliberating, they're far more likely to remember the story that told the example of the brain injury deficit, as opposed to the fact that somebody just came in and said, oh yeah, he doesn't think as well. So until then, remember this. The right expert presented the right way can make or break your TBI case. This has been Tom Crosley with Winning the TBI Case.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.